In 1875, Robert Todd Lincoln, the sole surviving son of the late President Abraham Lincoln and his wife Mary Todd Lincoln, attempted to commit his mother to an asylum on charges of insanity. He was successful. But what if Mrs. Lincoln were tried today in a present-day court under existing Illinois laws that govern mental health? We're about to find out as a modern-day audience becomes the jury in the insanity retrial of Mary Todd Lincoln. I'm Bill Curtis. Mrs. Lincoln's carriage is approaching the courthouse here in Chicago. She is accompanied by her defense team. The committal proceeding casts Civil War veteran Robert Todd Lincoln against his widowed mother. He's trying to have her committed to an insane asylum for several mental and behavioral disorders that you'll hear about during the course of the trial. May it please the court. Tonight you will witness a story that occurs nearly every day in this state and in this country. First, you have a person with a perceived mental illness. Second, you have a concerned family and a concerned family member trying to figure out what to do. How does this family member handle the situation? The purpose of this exercise is to see what the result might be given today's law and knowledge of medicine. The judge and attorneys on stage tonight will use the facts based on actual witness statements from the 1875 trial, the history of Mary Todd Lincoln's life up to 1875, and actual events that took place, but they will apply current Illinois law regarding mental health proceedings and the current state of knowledge regarding medical treatment of the case. In an actual commitment proceeding, a jury of 6 renders the verdict. But in tonight's trial, it will be up to each and all of you to decide whether Mary Todd Lincoln should be involuntarily committed for treatment. Before we proceed, please note that all witnesses have been sworn in. The proceeding begins with an opening statement by the attorney for the petitioner, Warren Wolfson. In his effort to support his client, Robert Lincoln is involuntarily committing his mother. Wolfson portrays Mrs. Lincoln as a woman in danger, racked with mental illness, at risk of harming herself.
It's not the kind of illness that doctors can see in an X-ray or find in a blood test. But it's real. And it's there, and it must be treated.
Wolfson details some of the life events that have exacerbated Mrs. Lincoln's condition, her tragic and innumerable losses.
Her son Eddie, 25 years ago. Her son Willie, 13 years ago. The president, 10 years ago. And her son Tad, 4 years ago. Each time, there was a long, isolated, painful period of mourning that continues to this day.
He further asserts that her son Robert makes one of the most difficult and anguished decisions of his life when he signs this petition as a preventive measure to guard against her possible suicide.
Death has been in her thoughts for a long time. Before she left the White House 9 years ago, she wrote these words: "I do not have the least desire to live."
Finally, the petitioner's counsel wraps up his opening statement by asking the jury for a life-saving treatment for Mrs. Lincoln. And that treatment is to commit her to an asylum.
On behalf of Mary Lincoln, we respectfully request that you not agree with him. On behalf of Mary Lincoln, we respectfully request that you do not deny her her freedom. You do not deny her her choice.
We continue now with attorney for the respondent, Mark A. Drummond's opening statement in defense of Mary Todd Lincoln. Drummond paints a portrait with different hues of the former First Lady, who he agrees is ill, but in no danger to herself or others.
I will tell you at this point what this case is and is not about. It is not about, and you will not be asked to decide whether Mary Lincoln did odd things. She did. You will not be asked to decide, did Mary Lincoln spend too much money from time to time? She did. You will not be asked, did Mary Lincoln suffer from a mental illness? She does.
Drummond and his team will argue that although Mary Lincoln has a mental illness, she should not be involuntarily admitted to an asylum, and to do so would be to take away her fundamental rights and liberties.